Hello, my name is Howard Kline, and I'm a trademark attorney at Nath, Goldberg & Meyer. Today, we're going to be discussing a recent decision by the Supreme Court of the United States in Abitron versus Hetronic. In this case, the Supreme Court held that the Lanham Act, the U.S. Trademark Act, is not extraterritorial in nature. And what does that mean? Well, Hetronic is an entity that is responsible for, in the United States, responsible for manufacturing, selling, and producing various radio remote control devices. They came to a contractual agreement with an EU entity that became known as Abitron to manufacture, sell, and distribute in the European Union. Over the course of the relationship, various disputes arose, and Abitron began to use Hetronic's marks on copycat products. Hetronic then asserted trademark infringement. Over the course of the litigation, Hetronic was awarded significant damages in this case. And the question became whether the defendant's use, which was in the European Union, was sufficient to constitute trademark infringement in the United States. The Supreme Court held it was not. Specifically, the Supreme Court held that a defendant's use must be domestic in nature, must be in the United States. Here, Abitron used the infringing mark, or the allegedly infringing mark, in the European Union, brought it to a trade show in the European Union, and there were Americans that became confused. What the Supreme Court held was it does not matter whether the likelihood of confusion occurred in the minds of American consumers. What was relevant was that the actual infringing use did not occur in the United States. And as such, there was no trademark infringement based on the Lanham Act. What does this mean for U.S. trademark holders? Well, while U.S. trademark registration is incredibly valuable, it may not provide the full scope of protection that some may have previously thought. What is a prudent course of action then? Well, you need to take a close look at where you're actually using your trademarks throughout the United States and throughout the world. If you're using your trademark in the European Union and Canada, it's very prudent to consider filing applications in those jurisdictions. So the most cost-effective way for a U.S. trademark registrant is to file what's called a Madrid application. The advantage of filing a Madrid application is you do not need to pay different attorneys in different jurisdictions at the time of filing. The disadvantage of filing a Madrid application is that you don't get the expertise from those jurisdictions, from attorneys that specialize in EU law, that specialize in Canadian law. And as such, in many cases, it may be prudent to file direct national applications. So really what we're advising our clients is take a close look, take a trademark audit. What our firm can do is take a look at where you're actually using your marks. What are the jurisdictions that you really sell a lot of products in that have value to your company? And if you don't have a trademark registration in that jurisdiction, it can be a really strong decision on your part to consider that, especially given this recent decision by the Supreme Court. U.S. trademarks are incredibly valuable, but they may not provide protection if the use does not occur in the United States, even if there is likelihood of confusion in the United States. So a lot of stuff going on here. A recent decision from the Supreme Court is being remanded to the lower court, so we'll see what happens, but something to certainly keep in mind. And if you have any questions about international trademark protection, please feel free to reach out. We can be reached at ip@nathlaw.com or by phone at 703-548-6284.